All right, guys. Well, good morning. My name is Dennis Ludick with Landmark Title. Howard was indisposed today, so they bring in the pinch Howard. I got the same haircut as him, but we'll see how this thing goes. You guys are going to be talking about the difference in the listing agreements that we have been using the NEFAR listing agreements for a long time. And as of July 1st, NEFAR says they are out of the forms business and that we are not using any of their forms. And they've also, all those forms are copyrighted. So technically you're not supposed to be using those at all after July 1st. So we're making this transition over to the Florida Realtors listing agreement going forward. So there's some differences between it. Honestly, just a quick overview of it. The NEFAR listing agreement is 9 pages long. The Florida Realtors listing agreement is 4 pages long. So 5 pages of bulk has been removed from it, which is really, really good. And whenever I was going through this, a whole lot of the stuff is stuff that would already be in the seller's disclosure or that would be in the actual contract itself. So, they just basically got out a lot of the fluff and the fat out of that 9-page agreement and have really just sort of tailored it in a little bit. So what I'm going to do here is I'm just going to go over the Florida Realtors exclusive right of sale listing agreement. And I'm just going to go section by section, talk about what they are, and whenever applicable, talk about the differences between the NEFAR version that we've been using as well. So, and I'll try to the best of my ability, tell you where you can sort of find that same language over on the NEFAR version of the document. So section 1, simple, just the authority to sell property. The difference here is that located within this section, it talks about real and personal property. You'll see that on lines 4 and 5. As we all well know, real property is land and or structures that are attached to, and personal property is all the stuff that's not. Our beds, our window, not even, well, windows are connected, tables, chairs, stuff like that. This is the exclusive right to sell all of that. And then what happens is later on in this Florida Realtors, I'm going to call it FAR. They don't like it because it's not Association of Realtors, it's Florida Realtors, but I'm going to call it FAR because I've been doing this for 20 plus years, and that's what we call it. So in the FAR listing agreement, it sort of incorporates, and it's your responsibility to list out all the personal property that is going to convey, okay? Wherein the NEFAR version of it in section F, or section 2F, excuse me, of the NEFAR listing agreement, it listed all these things. They were all hard-coded in, stuff that conveys, television wall mounts, window treatments, likes of that. And then you can always exclude certain things. In the FAR version of this, you're going to have to list all that stuff. Now, it does give you the option to add an attachment, see attachment. Honestly, what I would do is, since this is your agreement, between your seller and yourself, this is the agreement. It's a contract between you and your seller, right? So if there's ever any issues and this goes before a judge of any sort, this is going to be the most important document. So you guys want to be as specific as possible about what was meant to convey and what wasn't. The one that I always see is, the garage refrigerator, right? Well, guess what? You take out the garage refrigerator and you put it's a nice garage refrigerator. And then, at walkthrough, buyer finds out that there's a beater fridge been thrown in there. That's not what was intended to be conveyed. So be specific with it. I don't think you really have to get all the way down to model numbers per se. Hey. But, just brand model and stuff like that, describe it. All that stuff helps for the surety of the script. And again, this section number 1 versus, the NEFAR number 1, it's really the same. The only thing that the FAR version adds in there is the anti-discrimination language that we all, have to adhere to. The property is going to be offered to any person, regardless of race, color, religion, sex, handicap, marital status, national origin, or any other factor protected by federal, state, or local law. All right. And then description of property. Number 2, section 2 of the FAR listing agreement. Again, put down the street address, legal description to the best of your ability. You can also see attachment. What you may want to do, and what I always do, frankly, whenever I'm drafting up deeds, is I'll go find the last deed of record, find that legal description on that one. And we all have Adobe and stuff like that nowadays, cut and paste, and just add that and make that your attachment, because that is technically the legal description. That way you can't mistype something and get an error there. And then, like I already sort of mentioned about personal property, just be very specific about that whenever you guys are putting that in. Occupancy, again, property is or isn't currently occupied by a tenant. If it is occupied by a tenant, you got to let everybody know when that lease expires. All right, then section 3 of the FAR listing agreement is price and terms. Again, this is covered a lot in section 3 of the NEFAR listing agreement, but it's a little bit different. And again, NEFAR is just really, really, really bloated with a lot of extra language in there. For example, if you guys want to look at it, it's section 3C. It talks about the seller expenses, what the seller is going to pay in the transaction. Well, guys, that's all in the contract. That's all stuff that gets negotiated at the contract. We don't need to, have that done right here. And so the Florida Association of Realtors got rid of all that, like I said, fluff and sort of redundancy in it. You'll also see in that section under 3E, right? They got rid of tenant occupied property because, that's again, just talking about, that section of that agreement is out. Financial representation, that part is out as well. So when it comes to price and terms on the new listing agreement that you guys are going to use, again, property is offered for sale on the following terms or on other terms acceptable to buyer. Got to come up with a price, right? Financial terms, what's the seller willing to accept? Are they willing to accept cash, conventional VA, FHA, others? Are they going to do seller financing, right? Is the seller going to loan the buyer money by giving them a mortgage and by giving them a note and taking back a mortgage on the sale of that property? And then one that we're starting to see, but honestly, it's really hard, just the mechanics of it, is the assumption of the existing mortgage. That is actually located in 3B of the NEFAR listing agreement. And even then, they really don't talk about it. They say that you have to attach the mortgage assumption addendum to the listing agreement, which I'm not going to go into. But if you have a seller that is willing to have somebody assume the existing mortgage, just fill that out again as full as possible, as much as you can. Whereas the NEFAR puts in this little bit of language, says, hey, if seller financing or mortgage assumption, check with an attorney or a lender to determine the extent of potential liability. The FAR version sort of puts it all in there. And my apologies, guys, I'm terrible, so I'm going to move it to where I was at. Sorry about that. There we are. All right. And then something that is interesting, I thought was interesting, was this, like I said, the NEFAR version has that seller expenses, which is really in the contract, and they go into very, very, very minute detail. Basically, it's a lot of language that's lifted right from the NEFAR purchase and sale agreement. The FAR version just limits it to seller expenses. Seller is going to pay mortgage discounts or other closing costs not to exceed a certain percentage of the purchase price and any other expenses seller agrees to pay in connection with the transaction. Okay, so more detailed versions of what they're actually going to pay will be handled within the contract itself, but at least in the listing agreement, you can set a ceiling as to how much they are willing to pay towards settlement costs or expenses. Again, that's going to be handled in the contract. Section 4, broker obligation. Broker agrees to make diligent and continued effort to sell the property in accordance until a sales contract is pending. That is Section 5 of the NEFAR contract. It's basically the exact same language. Of course, it goes into a lot more detail, but that's on the NEFAR version. This just talks about, diligent continued efforts, which is what you guys have always been doing. All right. Number 5 of the FAR version of the listing agreement is the multiple listing service. It talks about placing the property in multiple listing services, how it's beneficial to the seller because it'll be exposed to a large number of buyers. And of course, as an MLS participant, broker is obligated within 1 business day. Basically, it's just letting the seller know all of your responsibilities to the MLS and what has to happen. Now, MLS is referenced in 5C of the NEFAR agreement, and where it authorizes the broker, to photograph the property, make sure it's put into the list, into the MLS so that it has the, broadest audience available.
So I have a question.
Yeah, please.
So can you clarify, 3C is where they would list seller concessions now. And then also in regards to VA assumption, how it would mess up their future eligibility if it's a non-VA buyer assuming.
Yeah, well, so I'll take the first one first.
Yeah.
Yeah. Yeah, no, so 3C is seller expenses. There is no place to put that on there, guys. So we wouldn't talk about concessions there. That is going to begin being the contract. Whenever we talk about, sellers willing to give X amount of concessions to the buyer towards closing costs, since we're not allowed to talk about compensations anymore. It's a lot of, they're concessions to buyer, right? And then the other one was
okay. So assuming a VA mortgage, so how it would mess up their future eligibility if it was a non-VA buyer assuming it. So essentially, the fact that goes towards their max that they can get from the VA for a loan. Yeah.
Honestly, I'm not familiar with that particular portion of that, and my apologies. But if we have the name of who asked that, I can find the answer and get it out to them.
Yeah, it's Mallory. So we'll find
perfect. Yeah, sorry about that, Mallory. Apologies. All right. So moving on to the next page is section 6 of the FAR listing agreement. And this here talks about broker authority, and that a lot of stuff is located in again the NEFAR version of this, but with a lot more detail. So what we have here is simply the broker authority. It allows the broker to market the property to the public, right? Public markets include flyers, yard signs, all that jazz. It also includes marketing the property to real estate agents outside of the broker's office. Place appropriate transaction signs on the on the property, and use seller's name in connection with marketing or advertising. But there's also not public market to the public, right? Seller does not authorize broker to display the property on the MLS, which frankly, we all know that hampers the ability of most folks to see the property. But they do have the right to say that. And then seller again understands and acknowledges that if they check that, the for sale sign will not be placed on property, and that if they check that, broker will be limited to marketing only to agents within the broker's office. And that's such an important part of this listing agreement that they actually require the seller to initial that specific section, because they want everybody to be fully aware that that's really, really important, and that you're really hamstringing you guys in your ability to market the property.
So question.
Mm-hmm.
So this thing where it says display the property on the internet except the street address. So is that what would be checked off if the community doesn't allow a sign? Because a lot of the HOA communities don't allow the signs in front of the house.
Yeah, well, a lot of HOAs, they also have specific styles that they're permitted to use. So you guys have to, if you're in a certain neighborhood, you have to have it. You can't have your default sign that you guys would put in a normal property. It has to be tailored to that neighborhood. Yeah, so has their own signs, and if you guys want to do.
Yeah, I just know like E-Town doesn't let you have a sign at all, like they'll threaten you.
That's not the box you check if it doesn't allow you to have a sign. That's the box you check if somebody said, I don't want people just arbitrarily driving around in front of my house to be a looky-loo.
Yeah.
So don't publish my address.
Yeah.
Okay.
So you would check that box. If you got a grumpy old person who says, I don't want headlights in my yard in the middle of the night, I don't want people looking like they're stalking my house, don't publish my address.
Yeah.
Oh.
You can still put a sign in the front yard.
Yeah.
Or if they tell you don't put a sign in my front yard, whatever.
Yeah.
And it can still be published on the internet, you just don't publish the address.
Yeah.
That makes sense.
Yeah, so if somebody wants to see the property, then obviously they'd have to reach out to you and you would show them around. Yeah, absolutely. All right. And then if you go down here to section 6 E of the FAR listing agreement, that talks about the lockbox system, and that is located in 5A of the NEFAR. But again, it's the same language, just put into a different way. Use a lockbox system to show an access. A lockbox does not insure it. You know, they're basically telling the seller, making sure that they're fully aware that it doesn't secure the property, but it does make it significantly easier to show the property when needed. But it is a secure system as well as we can be anymore. You can also withhold verbal offers. I noticed that one. That's on 5B. You know, they of the NEFAR version like that. So if your seller wants to, withhold a verbal offers or withhold all offers, once seller accepts a sales contract, they would just pick that checkbox to go with. Now, something that is completely unique to the FAR listing agreement that is not located at all on the NEFAR is this 6G, which is virtual office websites. And so what this deals with is these virtual office websites, basically the Zillows of the world out there, right? You know, that it does the automated estimated value, market value of the property, and it also allows reviews and comments on the property. May be displayed unless limited below. So the seller has the right to say, I don't want an automated estimate of the market value to show on these vals, or to allow third parties to write comments on those particular websites. So you have a question, somebody? So thought I heard somebody say they had a question. So that's something unique to the FAR listing agreement as opposed to the NEFAR. And then the next is the seller's obligations. Obviously, it's cooperative endeavor between you guys and your seller. And excuse me, this again just lays out all of their obligations. Frankly, they're the exact same ones that are located in section 6 of the NEFAR listing agreement. You know, there's really nothing new under the sun there, guys. Cooperate with you as the agent, whenever you need them to. Recognize, that you as the broker may be subject to additional MLS obligations, so that they need to help you to avoid, any penalties and stuff like that. Obviously, they're going to give you keys to the property so that you can show it. They have to let you know about anything that happens to the property. If they decide to put a lease on the property, if they decide to put another mortgage on the property. And it also indemnifies broker and hold broker harmless for any loss or damages, expenses. Again, that's exactly what's already located in the NEFAR agreement. So there's really no difference here, just a different way of showing it.
You're fine.
All right, guys. So moving on. We'll talk about the best part of this, right? Compensation. So section 8 of the FAR listing agreement talks about compensation. And again, it is the exact same thing as section 8 of the NEFAR agreement. It just looks a little different. Whereas where on this one, it breaks it out almost line by line as to what your commission is going to be for the sale of a property. It also talks about, breaks out on a separate line, the sale of an option or a leasing fee. Whereas it's sort of mixed together and muddled together a little bit in the NEFAR, in the FAR version of this, they just sort of list it out line by line. So again, seller's going to compensate broker as specified below, for procuring a buyer who's ready, willing, and able to purchase or any interest in the property, in terms of the agreement. And it's a percentage of the total service price plus a dollar amount, or a dollar amount no later than the date of closing, which is the way we always do it. And then again, an option or leasing fee has the exact same situation. Now, 8D talks about when the broker's fee is due. If any interest in the property is transferred, whether by sale, lease, exchange, governmental action, bankruptcy, or any other means of transfer, regardless of whether the buyer is secured by the seller, the broker, or any other person. So if any interest in the property conveys, you are due to be compensated. If the seller refuses or fails to sign an offer, a bona fide offer, at the price and terms stated in this agreement, defaults on an executed sales, or agrees with a buyer to cancel an executed, again, you're due your compensation at that time. And also, if within X amount of days after the termination date, seller transfers a contract to the property to somebody who the broker you guys identified, right, who was communicating with. So make sure you have to, and again, this is all sort of overarching in all agreements. If there's ever a blank space on a contract, please fill it in. Even if it says, if left blank 15 days, put it in 15. Today with Adobe and Acrobat, we can all just add things in there. Just makes it a lot easier if you have it, something filled in there. And if it's not applicable, just put NA in there. And again, that tells the world that there is, it's not applicable, and it makes it very much more difficult for somebody to place something in that space. All right, and then 8E, this is slightly different. It's also talked about in section 7 on the NEFAR. It talks about the deposit. This is retained deposit. So as consideration for the broker services, broker is entitled to receive, and this is again where I say fill this in. They just leave it half, or excuse me, blank, but they say 50% if left blank. Fill in, whatever the amount is. And frankly, it should be at least 50%, right? Of all deposits that seller retains as liquidated damages for a buyer's default in a transaction, not to exceed whatever your commission already would have been. Okay. So please fill that in, because that'll protect you. Obviously, if the deal, if the seller, breaks this and, or if the seller gets a binder back as liquidated damages under the contract, that'll protect you there. All right. So section 9, cooperation with and compensation to other brokers, notice the seller. Again, it's the same language that they have over in section 13 of the NEFAR agreement, where a broker relationship, where they're talking about, obviously, buyer's broker, even if compensated, may represent the interest of the buyer, right? Because you guys are transaction brokers. This is a listing agreement for transaction brokers. Broker's office policy is to cooperate with all other brokers, except when it's not in the seller's best interest, and to offer compensation in the amount of whatever percentage or a dollar amount to a single agent for the buyer, to a transaction broker, or to a broker who has no brokerage relationship. Those are the exact same parts that are in, it's section 8 of the NEFAR. My apologies for that. But it's the exact same language. Again, they just break it out there. And again, these are blank, so we want to make sure that they're filled in one way or the other, either a dollar amount or a percentage. And if you don't want to put a dollar amount in, you want to do percentage, put the NA, please. Make sure everybody's aware that, it's not both, or, give them an opportunity to act bad. 10, there's section 13, brokerage relationship. Again, you're a transaction broker on this. Honestly and fairly, nothing's changed here. Now, there is a new section here in the FAR version of the listing agreement. This is the conditional termination. This language isn't specifically in the NEFAR version of it. And it says that at seller's request, buyer may agree to conditionally terminate this agreement. If broker agrees to conditional termination, seller must sign a withdrawal agreement, reimburse broker for all direct expenses incurred in marketing the property, and pay a cancellation fee of whatever that amount is, plus applicable sales tax. So what that means is whatever, make sure you guys keep tally of all your expenditures that you do, so that if they decide, if at seller's request, they want to terminate this agreement, you get reimbursed for everything that you've spent on it, plus add a termination fee. And in talking to your broker, I think 1,500, I think is what you guys want it to be. But again, it's a blank, fill in something there, please. Because that, again, will protect you guys. Broker will void the conditional termination. The seller will pay the fee stated, less the cancellation fee if seller transfers or contracts to transfer or any interest during the time period of the date, from the date of conditional termination to termination date and protection period, if applicable. So again, same thing, within that protection period, you guys will get taken care of, reimbursed, and that termination fee. So section 12, we're talking about dispute resolution. That is section 10 of the NEFAR. And the difference here is in NEFAR, you immediately went to a non-jury trial. That's expensive. I mean, you got to get attorneys, you got to go in front of a judge decides what the situation is. There's a lot of motions and a lot of things back and forth that you guys can go through. The FAR version of this immediately says that you're first going to attempt any sort of dispute resolution involving with mediation. So you're going to go to mediation using under the rules of the American Arbitration Association or other mediator agreed upon between you and the seller. And again, what mediation is, it's an attempt to settle a dispute. It's usually not binding at all, but it's an idea as to, somebody trying to talk reason to all the parties, trying to get the deal done. If, however, mediation isn't successful, the parties don't agree to the mediated amount, then litigation can happen. But just like in the NEFAR version of the listing agreement, the prevailing party is entitled to recover reasonable attorney's fees and costs. So, like as an attorney who's practiced law here in the state of Florida for 20-some plus years in real estate, I've had plenty of folks come to me and say, well, I want to sue that person because that's my binder and this, that, and the other. I have to tell them, look, litigation is expensive and being right is very expensive. So always try to avoid litigation if you can, but unfortunately it does sometimes happen. But just make sure that everybody's aware that litigation and you lose, you're going to be on the hook for the other person's attorney's fees and cost. So hang in there. And then obviously miscellaneous, and that was section 13. This agreement is binding on sellers and brokers' heirs. That's located actually in section 12 of the NEFAR. Brokerage can assign this agreement to another listing office. Same brokerage, just a different office, right? And of course, excuse me. And then this is the entire agreement between the seller and broker. There's no other agreements out there that bind the two parties together. And obviously there's no oral agreements between the parties, and everything has to be reduced down to writing. And then you just have section 14, which is additional terms, and then the signatures and all that contact information, right? So a significantly smaller document than the NEFAR listing agreement. Specifically, I mean, I went through the NEFAR listing agreement, specifically like the seller expenses, like I've already mentioned, that's all removed because that's all addressed in the contract as to what the seller is going to pay in that transaction. Tenant occupied property, like the details of that are all out of the property. Financial representation, that is now out of this listing agreement. That basically says that, if the seller has to bring cash to the table, that they have enough funds, or if they're not going to have enough funds, it's going to be a short sale situation. They disclose that up front. That language isn't in the NEFAR listing agreement. So that's just one less thing we have to deal with there. Let's see, and then they also have, like in the NEFAR document, in section 6, down towards the very bottom of that section, towards the bottom of that page 5, it talks about property is subject to the following, HOA fees, master association fees, capital contribution. Again, all that stuff that's going to be located in the HOA disclosure which you're going to have to do as part of the contract whenever you get it under contract with the FR. And they also get rid of in there the section 11 of the NEFAR agreement. Gets rid of material facts and defects. Again, seller represents, seller has no knowledge of the facts. Again, this is all stuff that it's going to be in the seller disclosure. You know, we don't have to put this in the listing agreement. Florida Association of Realtors figured that out and have removed it from their listing agreement. And then there's also some bulky language in there talking about how if the seller is married, you know, they understand that their spouse is going to have to sign, you know, a lot of these documents in order to convey the property. And then again, it's sort of a disclosure also protecting brokers. Just talks about that you're not experts on tax, legal, financial, property condition, environmental, stuff like that. You guys are experts in marketing and selling properties, not in any of the ancillary portions of it, you know. And they also get rid of the FERPTA language that was in the NEFAR listing agreement. That's omitted again, because that'll be addressed in the FAR contract at that time. All right, guys. And so that's it. I mean, so there's really not much. I mean, that's what happens when you go from 9 pages down to 4. They rework a lot of things, and a lot of the stuff that was already going to be in the seller's disclosure or the HOA disclosure, you know, has been removed. So that's that. So are there any questions that let me see if I could figure this whole thing out. I got to be smarter than the computer, which is not very difficult for the computer to beat me on that. Let me see, do I have any chats or anything? All right. I'm not seeing anything, guys, and Nicole's not around to tell me that somebody has. So, and again, if you guys ever have any sort of questions at all, you can always reach out to me. I've got my information here in the office, but you guys can always email me. It's Dennis, DENNIS at landmarktitle.com. And I'll get right back around to answering any of y'all's questions. So for the new listing agreement?
Yes. Keep the same like when you tried they stand or things like that, or that new on it.
I'm not aware of any new amendments at this time. I mean, I know that the Florida Association of Realtors is in the middle of updating all of their documents. And I think they're saying, don't quote me, I think they're saying early August is when this should be ready. Yeah, August 15th or something like that, I think I've heard. So I'm not familiar with that, but we'll be ready once they come out and see what's changed and keep you guys abreast of all that.
Yeah.
Absolutely. All right, guys. Thanks. Take care.